Hello everyone, my name is Shadan Seraj and I am currently doing an internship under LEXIS and Company. So today we'll be discussing about res judicata. The doctrine of res judicata has been defined in section 11 of the Civil Procedure Code. It means that the matter is already judged. It means that no court will have the power to try any fresh suit or issues which has already been settled in the former suit between the same parties. Also, the court will not try the suits and issue between those parties under whom the same parties are litigating under the same title and matter are already been judged and decided by the competent court. While the court finds any suits or issues which has already been decided by the court and there is no appeal pending before in any court, the court has the power to dispose of the case by granting a decree of res judicata. They apply to all judicial proceedings, whether civil or criminal. For the application of this section, the following conditions must be satisfied. There must be two suits, one previously instituted and the other subsequent suit. The matter in the issue in the subsequent suit must be directly in the issue in the previous suit. Both the suits must be between the same parties or their representatives. The previously instituted suit must be pending in the same court in which subsequent suit is brought in any other court or in court beyond the limits of India, continued by central government or Supreme Court. The court in which the previous suit is instituted must have jurisdiction to grant relief claimed in the subsequent suit. Such parties must be litigating under the same title in both the suits. Now, what if the circumstances around the issue change? In the case of Krishan Kumar versus Vimala Sehgal, the Delhi High Court held that when the circumstances are changed, a second petition can be filed for own occupation even if the earlier application of the land laws is rejected by the rent controller. It further observed that the needs of the landlord when the petition was first filed in 1961 were limited. His son had not come from England, his children were quite young. He himself is a man of 64 years of age. He has retired. It would not therefore be right to say that the decision in the first petition operates as a res judicata. Obviously, the circumstances have changed. In changed circumstances, a petition can always be made. The scope of res judicata is not restricted to section 11. Res judicata is the principle which is also applied to the administrative law, constitutional law and criminal matters. It is applicable to other legislation and acts too. In the case of Shiv Prasad Singh versus Ramanandan Prasad Singh, Sir Lawrence Jenkins observed the rule of res judicata as the rule while finding on Asian precedent is dictated by a wisdom which is for all time. In the case of Dario versus the state of UP, the court stated that for this rule there would be no end to litigation and no security for any person. The rights of the person is involved in the endless confusion and great injustice done under the cover of the law. The doctrine of res judicata is based on the public policy, and this is the principle intended not only to prevent a new decision but also to prevent a new investigation so that the same person cannot be harassed again and again in various suits upon the same question. Now, the exceptions of the plea to res judicata are: if a court thinks that the judgment of a former suit is obtained by fraud, then the doctrine of res judicata is not applicable. When special leave petition or SPL is dismissed without adjudication or decision, then res judicata should not be applied. For obtaining the doctrine of res judicata, the former suit should be decided finally by the competent court. Section 11 will not be applied when there is a different cause of action in the subsequent suit. The court cannot bar a subsequent suit if it contains the past there are different cause of action. Interlocutory order in the interim order decree of sentence passed by the court, a principle of res judicata will not be applicable when an interlocutory order is passed on the former suit. It is because the interlocutory order immediate relief is given to the parties and it can be altered by subsequent application and there is no finality of the decision. Decree of res judicata is a plea in the bar which a party must waive. If a party did not raise the plea of res judicata, then the matter will be decided against him. It is the duty of the opposite party to make the court aware about the adjudication of the matter in the former suit. If a party fails to do so, the matter is decided against him. When the former suit is decided by the court, who has no jurisdiction to decide the matter, doctrine of res judicata is not applied to the subsequent suit. Then the doctrine of res judicata is not applied to the subsequent suit. Now the last one is when there is a change in the law and the new laws bring new rights to the parties, then such rights are not barred by section 11. In conclusion, the doctrine of res judicata can be understood as something which restrains either party to move the clock back during the pendency of the proceedings. The extent of res judicata is very, very wide and it includes a lot of things which even includes public interest litigation. This doctrine is applicable even outside the Code of Civil Procedure and covers a lot of areas which are related to the society and people. The scope and the extent has widened with the passage of time and the Supreme Court has elongated the areas with its judgments. Thank you.